Hello everyone, welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch, and I'm kicking it off with an update. She's back, and still a little feisty. If you happen to miss that appearance, link will be in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
Do I rise?
When the judge comes in.
Okay.
Oh, what do we got going first?
Ms. Jones.
Ms. Jones, how's Ms. Jones doing today?
Okay.
Russell, she was having trouble the other day.
Yeah, and I'm gonna hand up, Your Honor. First of all, this is on for arraignment, so I'll hand up my notice of appearance. Also, I was given a heads up that Ms. Jones was in custody. She's in the county jail at this time.
She's on the screen, Doug.
What's that?
She's on the screen.
Yeah, no, he sees her.
And so I'm gonna hand forward the 1077. We anticipate that there will probably be a finding of incompetency, but we don't know.
But no, I want to plead guilty.
Well, Miss Jones, the doctor's got to check you out first, see how you're doing.
This is bullshit.
Okay, that proves my point. So let's do the review.
Laugh all you want, Judge.
Oh, Ms. Jones, you and I go way back. I'm suffering
Fuck
with you.
you,
We've been through this before.
I'm pleading guilty.
I'm
I'm not going the fucking way.
If we could have a review May 4th.
May 4th.
I'm unavailable the 27th.
Yeah,
If it comes out as anticipated that she's not competent, this is one of the few cases that we've had in the past been able to successfully restore even on a short 29-day time frame. Usually the combination of Ms. Jones being able to detox as well as getting on her medication. If she's able to do that while she's in the jail, it speeds up the process. I'll also give Miss Tamara Vanover in the jail a heads up to see if she can help expedite this.
interesting, yeah.
But
Very good.
this is signed off, and if we could have a review on the 4th, if we do need a competency restoration period, I would ask we just do that ex parte and get it in as quickly as possible.
Right, yeah, no, we'll work with that. Of course, I'm always curious about what her current living situation is.
Well, right now it's in the county.
Right.
But the 27th, I'm going to be in trial, but
that's right, okay.
If we need to file a competency restoration order, I would just say do it ex parte.
Ms. Jones, we're gonna have you evaluated, so you're gonna be sitting there. Our next court date's gonna be May 4th. Hate to make you wait, but we gotta have you evaluated. I know you don't like that. Is that it for the county jail, maybe? Thank you, county jail. May 4th at 9:30. I'm assuming Mr. Paganelli, there'd be no.
No, he signed off on it as well. But yeah, this is, if it plays out, it has in the past, it's anticipated that she should successfully be able to be restored.
I just want to know what's your bar number.
28958.
Here's a guy that's a little bit older than you, Mr. Fong. Come on up, Mr. Fong.
Sonia Williams is accused of battery family violence from April 16th of this year, case 26CR2491D. Ms. Williams, you've been advised of your rights. How many, and her attorney is Mr. Sperber. Any priors?
It's a third. 2014 suspended license. 2014 hit and run, suspended registration. That's it.
Ms. Gardner?
Yes, Your Honor. This incident occurred at the defendant's residence, which is she lives at that residence with her son, Khalil Muhammad. Mr. Muhammad did admit to the officer that he was talking back to his mother and antagonizing her. Then he said he took the batteries out of the remote control to annoy her. He succeeded in annoying her, and the defendant chased him and struck him. He turned around to avoid her strikes and she scratched his back, leaving visible marks. The defendant also admitted that after Mr. Muhammad took the batteries out of the remote control, she did indeed strike him and throw him down. The officer did notice visible scratches on Mr. Muhammad's back that were bleeding, and they, as again, do live together at the residence. The state would recommend $1,500 bond, SOB jail, FVIP, no further violent contact with her son, Khalil Muhammad, no alcohol, weapons, or drugs without a prescription.
Thank you. Khalil Muhammad. And did you say a stay away as well?
No, Your Honor, I didn't ask for a stay away since they're both living at the same residence and their mother and son. I just asked for no further violent contact.
I'm just wondering where Mr. Muhammad is. I'd like to meet the brave person who interferes with an individual's remote control. No, not present? Okay. Miss Williams, your bond is going to be $2,000. It's going to be a signature bond through pretrial services level 1. You would have to report to pretrial once a month. Your monitoring period will be for 6 months, and you may report virtually. No violent contact with Khalil Muhammad. How old is Mr. Muhammad, by the way? Is he a grown man? Should be having his own job? What are we talking
I
about?
believe either 23 or 26, as those are the two children that reside. So I think he's above the age of 21.
Okay. So, Miss Williams, if that is your home, you're still welcome to go back there. Like I said, no violent contact with Khalil Muhammad. And if you, if you're ready to tell Mr. Muhammad to fly away and live on his own, that's entirely up to you. But in the meantime, please don't engage in any kind of altercation. Because you might be back in jail. Thank you.
Thank you, Judge.
Never mess with someone's mobile phone, and second in line is their remote control. Oh, did I lose my video? Okay.
Next is position 12, Miss Merrill, Your Honor.
Hi, sir. Could I please have your name?
Scott Carlisle, lady. And this is not a court hearing. This is a Zoom hearing. I have not put my hand on a Bible. I have not seen anybody put a hand on a Bible.
Right. Roll call case 228470 SM1. Mr. Leedy, you are here for arraignment purposes, and you're here with Mr. Jarboe, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Mr. Jarboe, did you have the opportunity to view the allegations on the bench warrant and the nature of the statement?
I can't understand a thing you're saying. All it does is echo in here.
I can speak up a little bit. Is this more helpful?
No, it isn't. It just echoes.
Right, is there an officer that's right outside that door?
Pardon?
Is there an officer outside the door who might be able to help us with communication?
Oh, there ain't nobody out here that I know of.
So I'm going to try and place you and Mr. Jarboe into a breakout room.
Your Honor, that's not necessary. We've already
Oh, have
spoken.
you already met with him?
So
Okay.
what I would share with the court is that it appears that Mr. Leedy failed to appear while out on bond for a competency hearing on January 27th of 2025. I have reached out to his attorney, Mr. Conley, who has already been assigned this file, but I have not gotten any information.
That's Ali
on
Khan.
that.
I know who he is. I fired
Okay.
him in the last court hearing, in previous court hearings.
So
He doesn't
I'm
do
going
his job.
based
There's no
upon,
investigations. There's no investigations, anything.
All right, Mr. Leedy, I'm muting you so that we can get through the court hearing, okay? Mr.
Based
Jarboe, if you could please continue.
thank you. Based upon my communication today with Mr. Leedy, it would be my opinion that he will be found incompetent. I don't have the report, but that's my educated guess. He will not be cooperative or understand what's happening today. So I would simply ask that the court schedule the matter at its most convenient and earliest time possible when Mr. Conley is available. I would ask the court to reach out to Mr. Conley to see when he can appear with Mr. Leedy to complete the competency hearing, which appears to be what was supposed to have occurred back in January of 25. And I'll leave it to the court's discretion regarding bond. I have no comment on that other than I really have no comment. That would be helpful.
Okay. We lost Mr. Leedy.
Oh, there you go.
Hmm.
Is he gone?
Yeah, he got up and left. Or is that in
Okay.
a different room?
Hi, I'm so sorry. We did not finish Mr. Leedy's court hearing because he walked out. But okay, so let's take care of this matter and then we can collect Mr. Leedy.
Hello.
Hi, sir.
Mr. Leedy is not wanting to speak to you anymore, and he did not
That's
use
okay.
very bad language.
Okay, that is okay. Mr. Dribble, I will remand him pending that next court date then.
I would just encourage
feel
the
it's-
court to encourage the court to set this as soon as humanly possible, but
Yes.
with due consideration for Mr. Connolly's schedule.
All right, we will encourage that swift scheduling.
Thank you.
May I have announcements of council?
Hunter Tabor for the state, ready?
Stephanie Yonts, attorney ad litem, ready.
All right, thank you, Mr. Tabor. You may proceed.
Thank you, Judge. I've submitted the court report and ad litem 3 exhibits. Exhibit 1 is the order of incompetency issued by Hayes County. Exhibit 2 is the competency evaluation of this patient. And Exhibit 3 is our application to administer psychoactive medications. I'd like these submitted as exhibits A, B, and C.
Any objection?
No, Your Honor.
Exhibits A, B, and C are admitted.
Thank you, Judge. And the state asks whether the ad litem will stipulate to the credentials.
I object. I have a right to be heard. I object to those exhibits because the hearing was never a legal hearing. I had a right to have witnesses, and the judge had she didn't even tell me about the court date. She told me I could represent myself. Never represented myself, and I represented myself in prior cases.
Okay, and so Mr. Barrera, you are going to have an opportunity to tell me all of that.
But I'm objecting to those. I'm objecting because I have that right to object.
I appreciate that, and I'm going to hear you on that in just one moment. But until it is your time to testify, I need you to you're not going to speak. Okay.
I got this question though. So that attorney did not object. So she's not collaborating with me properly to understand why I objected. And if she would have objected. So obviously y'all that's not an attorney. I didn't ask for an attorney. I'm representing myself. My God is my representation. She cannot be if she's not going to do it as I in the way that it's right and legal, then you can't give me an attorney. This is not it. That you can't use that for as my attorney. I have a right to be heard of, and I'm saying she's not my attorney, so I'm objecting to that.
And so right now you do have an attorney until I discharge her. However, I'm going to listen to what your objection is to exhibits A, B, and C.
Okay. The objection to which one was A again? I'm sorry. You got 3 of them.
Sure. So exhibit A is the competency evaluation. Do you have an objection to that?
Yes, the competency evaluation. So the doctor who did the evaluation, she failed to address that I do know how to address pertinent facts. She lied under oath saying that she did not recall me representing myself. She also failed to address that I had a court hearing officer who said I am quite articulate. He wasn't going to appoint me an attorney. And
do you have any other objections to exhibit A?
That's it. Those 3.
Okay. And so exhibit B is the incompetency order. Do you have any objections to exhibit B?
Yes, because I was never arrested. The arrest was illegal. I'm literally kidnapped. I'm telling the courts right now, I have literally been kidnapped from the inside of a store because it does say you have to lawfully arrest. Okay, so if you have it, that's why it's called an illicit detainment. Since that was illicitly arrested and detained, means any fruits that the courts may give after that is cannot be used. So you cannot say if I'm incompetent based off of anything because I was never arrested. So the courts cannot say I am incompetent because I was never arrested. So I was never, this is an illegal, and not only that, like I shared with you, again, for the reason why I said a court order, it was not an illegal court order because my daughter has called to this facility as well as she's already wrote a statement to the courts, to those Hays County courts saying, you did not let me testify and he's supposed to have witnesses. So
Mr. Barrera, I'm asking you about specific objections that you have to these documents. You are going to have an opportunity to tell me everything you want to.
It's illegal. I've been kidnapped.
All right, thank you. Do you have any objections to Exhibit C? That is the application to administer medications.
Yes, because first off, it's an unusual drug. I've never taken it. It's against my religion, and the psychs do not believe the way I believe, and so they're calling me. They're anti-Semitism. That's why they're trying to give me psychosis medicine.
Okay, all right. Do you have any other legal objections to these documents? All right, thank you. All right, and I have admitted Exhibits A, B, and C. Mr. Tabor, go ahead.
Thank you, Judge. The state asks whether the ad litem will stipulate the credentials of Dr. Sneed as an expert in the field of psychiatry.
I so stipulate.
Thank you. Mr. Tabor, you may proceed.
Thank you, Judge. And state I'd like to call Dr. Sneed.
All right. Thank you, Dr. Sneed. Would you please raise your right hand for me? Do you solemnly swear or affirm that the testimony that you may give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you. Go ahead.
Thank you, Judge. Doctor, please state your full name for the record.
John Sneed.
And how long have you been a practicing psychiatrist?
I graduated from medical school in 2015, so well over 10 years.
And what facility are you currently working at?
Montgomery County Mental Health Treatment Facility.
And is Mr. Barrera a patient of that facility?
He is a patient of Martha Grimaldo, and I am supervisor.
Okay. Have you had an opportunity to meet with him?
I've met with him twice.
And when was the most recent time that you met with him?
I met with him this morning.
And do you have enough information at this time to render a diagnosis of this patient?
Reviewing the notes from Martha Grimaldo and based on my assessments, the working diagnosis at this time is schizoaffective disorder bipolar type.
And what are the primary symptoms of schizoaffective disorder bipolar type that he's currently exhibiting?
He has an irritable or hostile mood, increased energy. Sometimes he has this pressured, loud speech, difficult to interrupt. He's also at times paranoid, accusing me of trying to make money.
That's speculation. Objection. That's speculation. Paranoid. Objection. There's speculation to that.
Objection is overruled. Go ahead.
He's voiced delusional beliefs in regards to a grand conspiracy from his county conspiring against him. He's claimed to receive messages from God through the TVs at times, hearing God's voice, kind of hyper-religious at times. So those are some symptoms that he's been experiencing, yes.
And now would you classify his symptoms as persistent and severe?
Yes.
And as a result of the patient's mental illness, do you believe that they lack the capacity to make a decision regarding the administration of psychoactive medications?
I do.
And do you believe the patient's mental illness impairs their ability to fully appreciate the risks and the benefits of the proposed treatments that you've offered to them?
I do.
And is the patient going to any classes at all at your facility?
He has refused.
And has he given a reason to your knowledge as to why he's not going?
He feels like it would legitimize the state, I think, that he says it's programming. He doesn't want to be programmed by the state. He keeps talking about being kidnapped and that he shouldn't even be here.
Okay. And is he taking any medications at all since he's been there?
He's not taking medicines, no.
Okay. Has he given any reason as to why?
He's mentioned that he sees me as almost like, he sees the medicines almost as sorcery, and that it is it's obviously something that he would not want to put in his body. He's mentioned that it's against his religion, but it's kind of hard to determine how his religious beliefs fit into anything that is considered within the norm that I know about Messianic Judaism. He also just says he doesn't need medicine, that he's completely competent, and that he has his wits about him, so he doesn't want medicines.
Okay, and what classes of medications are you asking this court to order the patient to take?
Antipsychotic medications and mood stabilizing agents, first and foremost, and then more secondarily, like sedative, hypnotics, as needed.
Okay, now those classes of medications that an expert in your field would normally prescribe to somebody with schizoaffective disorder bipolar type?
Yes.
And what are the likely side effects of these classes of medications?
Well, there's common side effects like nausea, vomiting, diarrhea, or constipation. There's also things like muscle stiffness or tremors. But then there's also more rare side effects like decreased white blood cell count. But most of the, a lot of these symptoms or side effects are able to be managed at our facility very well.
So your facility is equipped to monitor for any of these possible side effects?
Correct.
Do you know if the patient's ever taken any of these classes of medications?
Not to my knowledge. Also, I want to add more side effects, possible sedation and weight gain. Yes.
Okay. And are there any other less intrusive treatments that will likely produce the same results as these medications?
No, nothing is effective.
Would the patient regain competency without these medications?
No.
Do you believe that these medications would give the patient the capacity to start attending classes?
Well, I think, yes, I think this will improve his mood and his thought process so that he'll be able to be more willing and more able to participate and do well in classes.
And that would assist him in regaining his competency?
Absolutely, yes.
Okay, thank you, Doctor. I'll pass the witness.
Any cross?
Yes, Your Honor.
Go ahead.
Thank you. Dr. Sneed, you mentioned that you've met with this patient only 2 times. Is that correct?
That is correct.
And one time was this morning?
Yes.
When was the other time that you met with him?
I believe it was the time that I had filled out the application. I think it was like a week and a half ago, approximately.
Okay. And who's the doctor you said you were supervising?
The nurse practitioner, Martha Grimaldo.
Okay. And how often has Martha Grimaldo seen him?
Oh, she's seen him more than she's seen him about 7 times.
Okay. And so do you feel confident making this determination that medication's needed, having only met him in person yourself twice? I
do. I've spoken with Martha. I've read the notes extensively, and even my own evaluation, just very briefly, I could see the signs and symptoms of mental illness pretty quickly.
Have you given him any, or has he received any emergency medications?
No, I don't think he has. No.
Has he caused any problems on the unit?
I mean, I don't know. I mean, cursing people out or things. I mean, nothing that would warrant like a code green or anything. No one has been in danger.
Okay. Do you think that he's a threat to harm anyone without having this medication?
I mean, he gets angry and he curses people out, but I mean, based on his behavior, he has not actually harmed anyone yet. But there's the hostility and belligerence is there, and I've definitely sensed it. So, I don't feel comfortable talking with him one-on-one. I'd want safety present, but he has not done anything to cause harm to anyone else. No.
Okay. And does he have any history of taking medication?
I tried looking in the computer. I couldn't find any history of him taking medications in the past. No.
Okay. Have you been able to talk to his friends or his family members about his treatment?
I believe his daughter was talking to Martha, and I joined in on that conversation. I spoke with her briefly, and yes, so I've spoken with her a little bit.
Was she able to give you any insight on her father's condition?
She actually is squarely believes there's nothing wrong with him, that he can't be taking medicine. They don't want him to take medications. It was hard for me to even explain though, like the situation. She doesn't even agree. She claims that he was kidnapped. She agrees with pretty much everything that he's talking about, which, from what I've seen from all the legal documents, doesn't seem to be what's going on.
Okay, so she wasn't able to tell you any medication that he's been on or any therapies he's ever tried?
No.
Okay. And he has mentioned religious reasons for refusing the medication. Is that correct?
Yes, he's mentioned that, but I looked up, Messianic Jew, and I didn't see anything that against their religion that can't take medicine. That's.
Let's get the Bible. Let's just get the Bible, and we'll show it like that.
Okay.
Are there any less restrictive options that would likely produce the same results as medication for Mr. Barrera?
No.
Are there any medications that has he taken any medication at all since he's been there?
Not to my knowledge, no.
Okay, thank you. I pass the witness.
Any redirect?
No, Judge, it's at rest.
All right, thank you. All right, Ms. Yance, you may proceed.
Thank you, Judge. I'd like to call a proposed patient.
All right, Mr. Barrera, would you please raise your right hand for me?
I'm not swearing. It's against my religion to swear. I swear.
You do not need to swear, but you do need to affirm to tell the truth.
I'll tell the truth.
I need you to raise your right hand for me.
That's religion. I'm not doing your religious.
It is not. And if you do not, then you will not be allowed to testify.
I can testify.
No, sir. No,
So
sir,
you're
you
saying that
cannot.
My constitutional right because I don't want to follow your laws, your ways. It's against my religion.
It is not, sir. I'm not asking you to
I'm telling you,
swear.
I'm telling the truth.
No,
You got
sir.
my word.
No,
This is
sir.
how I speak.
You raise your right hand and you affirm to tell the truth, or you do not get to
Oh,
tell me anything.
I'm affirm to tell the truth.
Sir, raise your right hand.
I'm affirm to tell the truth.
You,
I
Mr.
did.
Barrera, if you want to testify, you raise your right hand.
I just did. I just did it in front of you.
Raise your right hand until I tell you you can put it down.
So you don't order me. You're not my God.
I am not suggesting that I am your God, but if you want to testify, you're going to follow this
So you're
court's
telling me,
rules.
so this court, it's all right. My family's already calling 911. I will fight tonight if they inoculate me with drugs because I am not harm myself. You don't know if it gives me any allergic reactions. You don't know
Mr.
what
Barrera,
drug that they're going to give me.
Mr.
I'm
Barrera,
in perfect health. I'm in perfect health.
if you want to tell me anything, you raise your right hand now.
You can disregard all what I said, but I'm telling you, I already raised my right hand. I already
No,
did.
sir.
I already
You're
did.
going to follow the
I don't
rules
follow
of
your
this.
rules. I follow my God's rules.
Then I'm not, then you do not get to testify. Ms. Jans, do you have anything else?
No, Your Honor, we rest.
Thank you.
That's
I'm
fine.
granting
I
the
will fight
application.
tonight. I will fight tonight if they inoculate me because you will be assaulting me. It's against my religion. You don't know about religion.
I offered you, Mr. Barrera, I offered you many times to tell me about all of your defenses, including how this is against your religion. But if you will not, Mr. Barrera, if you do not follow this court's rules, you do not get to testify. It is up to you.
So there's a law that says that you can deny me to testify if I don't follow rules?
Yes, sir.
That's in the Constitution.
Yes. Sir, you're either going to raise your right.
Constitution. I
All
can
right.
show you that.
So I'm granting this application, and
You're
Mr.
adding to the
Barrera, you
rule.
are
You're adding to
excused.
the Constitution. You can't add. You can't add or suppress. That's against the law. It's unconstitutional.
All right.
It says I have a right to be heard, and it didn't say that I had to go under oath. There's no law that says that. There's no constitutional law that says. I mean, no federal law says.
Mr. Barrera, you are excused. You are excused. You are excused.
Cool. He's full of crap. Yes.
All right. Are you getting Mr. Wolford?
Yes, ma'am.
All right. Thank you.